I'm PALAK AGGARWAL of Hidayatullah National Law University and currently a legal intern at LEXIS and Company. I hope you guys are fine. In today's video, I'll be discussing about remedies of breach of a contract. In the event of violation of a contract, the aggrieved party is entitled to certain remedies. The remedies available to the aggrieved party are as follows: damages, quantum merit, specific performance, and injunction. Now let us discuss all of them briefly. Damages. It is the most popular relief for the breach of a contract. This way, the plaintiff is compensated for the loss he has suffered. Burden of proof to show that breach has been happened lies on the plaintiff. The next is quantum merit. It is a Latin term which means as much as he deserves. The party has done something, performed his part. Before the breach of contract has happened, he is entitled only to the part which he has performed. Next is specific performance and injunction. Sometimes, except for asking for the compensation in terms of money, plaintiff has an alternative. He can ask the aggrieved party to perform a specific part of the contract, the whole contract, may even restrain him to the breach. That is known as injunction. To be measured, the actual loss suffered by the plaintiff. The damage could be contained or mitigated, not be calculated while measuring the damage. It is expected that a reasonable man would take necessary steps to mitigate the damage. Damage is calculated as to what would be the position of the party if the contract would have been performed. Like thoughts where the objective is to put the person to a position where he would have been if the thought wasn't committed. Damage is calculated meaning that the expectation of the party of a reasonable profit is fulfilled. Following are the type of damages available to the aggrieved party. The first is ordinary damages. These are the general damages that arise due to natural course of business cause of the breach of the contract. Next is special damages. These are the damages which are caused to the plaintiff due to unusual circumstances. Recovery of this type of damages is not possible until unusual circumstances are brought to the knowledge of defendant. For example, in case of Simpson versus North Western Railway Company, the plaintiff consigned an order and wrote in the consignment that the order should reach Newcastle Monday. The plaintiff was in a habit of exhibiting his implement, asked the defendant company to deliver the goods to the Newcastle but did not tell about his intention of exhibiting the sample. Because of the negligence of the defendant, the samples could reach only after the show was over. But due to the knowledge of the defendant about the shows of the plaintiff, he was asked to pay not only for the loss but also the profit would have made if the show happened, if the goods delivered at the right time. He was aware of the unusual circumstances. Exemplary damages. These are the damages which are awarded to the wrongdoer not only for the breach of contract but also the compensation for the injury suffered by the plaintiff. The next are nominal damages. These are awarded neither as compensation to the aggrieved party, neither as the punishment to the wrongdoer, but as uphold the right of the plaintiff. Suit for injunction. Court may order injunction to stop the person from committing a particular act. This is done prior to the event expected incident as a preventive measure. This injunction can be permanent or temporary in nature. As a general rule, injunction is normally not provided until the act will cause huge damages to the plaintiff. Court may grant specific performance if the breach would be detrimental to public interest. I hope you guys found the video informative. In the next video, I'll be discussing about bailment. Thank you.